Tyler Brands on behalf of the Office of Public Defender.
I was gonna say, we have one of those. I don't know if we need two, but we'll definitely need a prosecutor.
It's a flashback.
Hold on, I don't think we're ready to start with them yet. B, I'm sorry. Or are you not ready? Okay, go ahead. I'm sorry, B. Just go ahead and bring him in. It's Friday. Or is it Monday?
No.
Please tell me your name.
My name is Dennis Ramos.
21MM194. You're here because a capias was issued for your arrest for failing to appear for a trial on 2 charges of battery. Your bond is $1,000 on each count, and I'll appoint an attorney to represent you. Good luck, sir.
Thank you.
Please tell me your name, sir.
Samuel Lamar Taylor III.
A capias was issued for your arrest in 19MM9583 for failing to appear for a status hearing on a charge of trespass on property other than a structure or conveyance. It looks like the judge authorized mental health pretrial release, but we got a note saying that you don't qualify for that. I'm going to appoint an attorney if there wasn't one already. No, it looks like you were appointed, Counselor.
Would he qualify for straight PTO, Your Honor?
I also think he has a detainer out of Volusia County. Is that still active?
Yes, Your Honor.
And he has a charge of violation of a condition of pretrial release. So here's a conundrum. I can't actually change another judge's capias. However, he doesn't qualify for what the other judge ordered.
You keep the mental health pretrial release on the warrant, but then make a note that if he does not qualify, which he doesn't, just set a low monetary bond.
I don't actually think I can do that. I am confident, though, I know Judge McGinnis pretty well, I'm confident that he would be okay with a low monetary bond. But it's a capias.
Can he be re-interviewed here? Or he's already been re-interviewed and has...
Right, he's not going to qualify. It's just a function of logistically, how do we do this? Here's what I'm going to do. I'm going to see if we can contact Judge McGinnis. And get an order from him. Can we call him back at the end of the docket? I'll see if I can get an order so we can modify this. We'll call you right back, sir.
Thank you, sir. Thank you, ma'am.
Yes, sir. Are you ready now? All right. We're going to do these, B, and then the next one. No. What happened to yesterday? Didn't you guys do these on Thursdays? No, it doesn't matter. I'm just asking because, oh, hold on. Trying to get the judge on that one. I know that name. The date's not on this one? We can do it. Oh, did I miss one? I'm sorry. I was caught up on the date. Your signature's not on it either. Oh, I put the wrong date. It's the 2nd and I put the 7th. I don't need to rush this. There's only one here. Okay. Okay.
Thank you.
Oh. All right. You as well. All right, I'm ready now. Please tell me your name.
Sapphire Franklin?
21MM271. You're here charged with battery. There is probable cause. I'll appoint an attorney to represent you. Does the state have any objection to pretrial release in this case?
No, Your Honor.
I'm going to place you on pretrial release with special conditions. You're not allowed to have contact with the victim in this case or the co-defendant or any witness. Do you understand what no contact means?
Yes, they gave me the paper.
I'm sorry?
They gave me the paper.
All right, you're not allowed to possess a weapon of any kind, firearm, or ammunition. You're not allowed to
Your Honor, just a moment, if I can look at, because I believe one of the co-defendants slash alleged victims might also be here. They all live together.
I think they are,
Um,
and they can't live together now. So you have to maintain a separate residence from Danielle Allen as well as Jorge Alarcon. Do you understand that?
Yes.
I'll allow one-time return with law enforcement to gather your belongings, but you three can't talk about that. Do you understand? Any other conditions the state would request?
No, Your Honor.
All right, good luck, ma'am. She has to dial into the link. What's this link? Is this from you guys or the JA? No, she has to call the link. Is this Stephen Bodley? We're going to have to pass him because he is an attorney, but we're not calling her on the phone. She's got to contact us. It doesn't work well in the courtroom. Please tell me your name.
Roger Jones.
Oh. A warrant was issued for your arrest in 21 CF 7190, charging you with 2 counts of sexual battery on a child under 12. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Does the state wish to be heard on?
Your Honor, as this is a PBL, I would ask for no bond on both counts.
At this time, you will be detained without bond.
He is entitled to an Arthur hearing as well, Your Honor.
He is. What will happen is your attorney will file a motion in front of the trial judge who's hearing this case, and that judge will determine bond at a later date. But because this is a first-degree felony punishable by life in prison, at this time, you don't have a bond. However, even while in custody, you can't have any contact with the victim or the victim's family members. Do you understand that?
Yes, ma'am.
All right, good luck, sir. Please tell me your name.
Yes, Stephen Bernard Mickens.
A warrant was issued for your arrest in 21 CF 7192, charging you with sexual battery on a child under 12. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. The state wish to be heard on this charge as well?
Yes, Your Honor. Again, as it's a PBL, I would ask for no bond.
No argument, Your Honor, but he is entitled to an Arthur hearing downtown.
All right, that is correct. At this time, you'll be held with no bond until your attorney files a bond motion in front of the trial judge because you're charged with a first-degree felony that's punishable by up to life in prison. Even while in custody, Mr. Mickens, while in custody, you still can't have contact with the victim or the victim's family. Do you understand that?
Yes, ma'am.
All right, good luck, sir. Please tell me your name.
My name is Orville Miller.
21 CF 7790, you're here charged with battery on a uniformed licensed security officer and trespass on property after warning. There is probable cause in this case. I'll appoint an attorney to represent you. Your bond is $2,500 on count 1 and $100 on count 2. You're not allowed to return to 800 West Central Boulevard. Do you understand? Mr. Miller, do you understand what I just said? Mr. Miller, do you not want to be here in court today? I can't hear you. Can you get closer to the microphone? Can you hear him, counselor?
He says he's supposed to be going to Aspire. He doesn't know what this is. That's what I heard, Your Honor.
Okay, I'm sorry, I couldn't hear that. I don't know anything about you going to Aspire, sir, but at this time, you're here because you're charged with a felony and a misdemeanor. I've already given you a monetary bond, but you can't return to this place, which is 800 West Central Boulevard, and you can't have contact with any of the victims or witnesses in this case. He's out on an ROR and a trespass.
He-
No, that's not. The man is a good man. I just want to go to the
He is, Your Honor.
Let me go to Aspire and see what that.
Sir, I don't have the jurisdiction to order you into Aspire. That's not something this court can do. So what you need to do is call the number on the piece of paper that the public defender's office is going to give you and talk to your attorney about getting you some help. I can't do that today. I'm not going to revoke his trespass, though. All right, good luck, sir.
Good morning, how are you?
Please tell me your name.
Danielle Allen.
21MM you're here charged with battery. There is probable cause. Counselor, do you represent her?
I do, Judge. Rahul Parikh entering an order tennis motion, order tennis notice of appearance in this case. The co-defendant/victim was actually just seen by Your Honor earlier this morning. Ms. Allen does reside at 251 Oak Run Court. She's never been in trouble before. She's got 3 children, a husband, both parents living there. She has owned a business in Apopka for 20 years. Doesn't own any firearms. She fully understands she can't have contact with that individual. She can't possess firearms. We're just asking for PTR and to allow her to return home. And Judge, as way of some background, she is actually the owner of that residence. She's on the deed. The other individual is actually her husband's niece, who is kind of couch surfing, being transient. They took her in, tried to do a good deed. This happened, and now we're here. She's never been in trouble before.
I see that. Is her husband on the deed as well?
It's her and her father, but her husband lives with her.
All right.
For the last 10 years. I'm the caretaker of my dad as well. I've been taking care of him for 10 years because
Get closer to the microphone.
he's 100% disabled.
Who is?
My dad is 100% disabled veteran. So I've been actually his caretaker for the last 10 years as well.
And I believe he resides there with her family.
I'm the owner and he's the co-owner. My dad is.
And Judge, you did order the co-defendant to go back one time with the deputy, and you told her not to go back there. So
Right.
there would be no conflict with that order.
All right, here's what I'm going to do. I'm going to grant your request, counselor. I'm going to place your client on pretrial release with special conditions. You can't have any contact with your niece. Do you understand what no contact means?
No problem.
Okay, you can't possess a weapon, firearm, or ammunition. Your attorney told me already that you don't have one, so that shouldn't be a problem. I will allow you to return to the residence. I don't see any alcohol or drugs alleged in this incident. Does the state see anything else?
I did not, Your Honor.
It seems like a family.
Yes, Judge, unfortunately.
Situation
and this
that
may end up being
escalated.
something that's a mutual combat situation or a declination, a prosecution type of thing.
Well,
Well, we'll see.
throwing
what-
cherries.
Sure.
So, right. I
Right.
read it. Okay, so that's going to be my order. I'll allow you to return to the home. Just keep in mind that you can't have any contact with her and she can't have any contact with you.
No problem.
So she's going to return one time with law enforcement to gather her belongings. I would talk to your attorney about where you should be when she does that and any other advice that he has, just so that you don't run afoul of any court orders.
Not going to have any problems.
All right, good luck, ma'am. Thank you, counselor. We have Leslie Sweet on the
Judge.
line now. Thank you, have a good day. Oh, have a good weekend. Happy 4th of July.
Judge, have a great weekend.
Let me see if I can get her. That was Stephen
Welcome to an
Godley.
Acano meeting. You are entering the meeting now.
Good morning, Ms. Sweet. It's Judge Gibson. Can you see us and hear us?
Good morning, Your Honor. I can see you, and how are you?
Excellent. How are you doing?
You look beautiful.
Oh, thank you. Well, that's a good Friday morning.
All covered up in masks.
Yeah, can't do the mask. And the AC isn't working, so I'm also not wearing a robe. But, you know, it's what we do. So I believe you're here, if you want to go ahead and put your appearance on the record.
Yes, my name is Leslie A. Sweet. I'm entering a notice of appearance on behalf of Mr. Bosky Otley.
All right, sir, tell me your name one more time.
Stephen Roland Bodley.
All right, so you're here because a warrant was issued for your arrest in 21 CF 7812, charging you with sexual battery on a child under 12 by someone older than 18 years of age. Because it's a warrant, another judge has already found probable cause. Does the state wish to be heard on this?
Yes, Your Honor, as this is a PBL, I would ask for no bond.
Ms. Sweet, the state is asking the court to detain your client pretrial with no monetary bond because it's a first-degree felony charge punishable by life in prison. I am inclined to do that.
The only thing I would point out, Your Honor, may I be heard?
Yes, please.
Point out to the court is that the client has no criminal history. He was arrested on his last day of finishing up the police academy. And I know that the state probably doesn't have all the facts in this case. He's not a danger to the community. But I see you have a lot more paperwork than I do.
I reviewed the affidavit, even though it was a warrant which another judge had already signed. I did review the affidavit. And there is definitely probable cause in this case to sustain the charge. If you want me to make a finding of whether there's proof evident presumption, great, I can do that this morning. But if you want to preserve that argument to ensure that your client gets that full hearing downtown.
Yes, I do want to preserve. Because I couldn't find the case number online, Your Honor, could you give me the case number and what division it's assigned to?
It's 21 CF 7812 AO, but I don't have a division. Oh, it's 16. I do have that. I didn't see that. It's Division 16.
Okay, we will file a bond motion downtown.
I agree with counsel. That's probably in your client's best interest. You have some very compelling arguments, and I would think you'd want to make those to the trial judge because that's who can set a bond in this case. I will just say, Mr. Bodley, even while you're in custody, don't have any contact with the victim or the victim's immediate family. Do you understand?
Yes, ma'am.
All right. Good luck. Thank you. And thank you, Ms. Sweet, for appearing. Sorry for the confusion. The phone lines don't work well.
Thank you so much, Your Honor. Have a wonderful weekend.
You too. Happy 4th.
Bye, bye, bye.
Please tell me your name.
Acorn Phillips.
21 CF 7796. Counsel, you want to put your appearance on record?
Yes, good morning, Your Honor. Chelsea Simmons for Mr. Phillips.
All right, sir, you're here charged with fleeing or attempting to elude a law enforcement officer with lights and sirens activated and driving while license suspended or revoked. There is probable cause in this case. Counsel, did you wish to be heard?
Yes, Your Honor. I would first make a probable cause argument.
Oh, go ahead.
There may be probable cause that a fleeing occurred, but as far as the identity of the perpetrator is unclear from the affidavit. The affidavit states that the officer was able to identify Daquan Phillips as a possible driver. It doesn't explain how. He's not the registered owner. And then it says that he showed another deputy his photograph and was able to positively identify him, but there's no narrative regarding what the other deputy's role was in the traffic stop. It's a different one than the one who attempted to stop this vehicle. And so I don't believe that there's probable cause for the charge.
What says the state?
Your Honor, I believe due to the defendant's history, the officers were familiar with him, and I believe that is how they were able to identify him.
Well, is there anything that's, so I did read this, and I read the sentence where it says he was able to positively identify Daquan as the driver of the vehicle. Why isn't that sufficient? If we have a law enforcement officer who says to another law enforcement officer, that's the guy that was driving, why is that not sufficient?
Yes, Your Honor. So the officer who wrote the report is Saboteur.
Yes?
It says that I attempted to conduct a traffic stop, and then down here it says that Deputy Anderson Dupiton positively identified him. It does not say where he was, how he saw him driving the vehicle, if he was even there. It's just wholly deficient in the identification portion of this affidavit. I also would object to using his prior record, as it doesn't state that he's fled in this car before. I'm also aware that there was a prior fleeing, but it was dropped. So when the police say that he had a prior conviction and other arrests, that is simply not true based on my search of the clerk system.
I conducted a query of his criminal history and arrest history. The query showed he's a 3-time convicted felon and has been previously arrested multiple times for fleeing and eluding resisting arrest.
Yes, Your Honor.
Let it be noted, one of the felony convictions is for fleeing and eluding law enforcement.
I was able to find a 2017 arrest for fleeing that was null-prost. There are not multiple charges of resisting or fleeing. His prior convictions, I believe, are cannabis and a false verification of ownership and a grand theft.
Carrying a concealed firearm, grand theft, false verification, cannabis, VOP, disrupting educational institution.
Right, it's not listed on the information sheet either.
So if the law enforcement officer is wrong about that, how does that affect the probable cause determination?
Well, first, I don't think that it goes towards probable cause at all. I mean, saying someone has a previous fleeing does not mean that they fled in this case.
I agree with that.
Okay, so additionally, the officer is trying to say that, is trying to make a propensity argument, which is improper in court, and is wrong about that. He spends a lot of time talking about Mr. Phillips' supposed prior record, but no time explaining how they identified him as the actual driver who fled in this case. They don't talk about who registered vehicle is, any statements made by Mr. Phillips when he was arrested later, there's a whole host of things that could be said that weren't.
All right, so I think you have a lot of interesting arguments. I'll tell you where I am with probable cause and tell me where what I'm missing. Based on the 2 statements, using law enforcement databases, I was able to identify him as the possible driver. Then I showed it to the other deputy who was able to positively identify him as the driver. I don't see how anything else other than those 2 statements makes it less probable to believe that your client was the driver, right? It's probable cause, right? Not beyond all reasonable doubt.
Sure.
It's cause to believe he probably was the driver.
The problem is that this officer, Anderson Dupiton, this 2-page affidavit is wholly devoid of any statements that would say where he was, whether he actually witnessed it. We don't know if the officer Saboteur described someone or saw someone. I mean, from this affidavit, they were behind the car the whole time. So it's really unclear how they would have seen the driver, who saw the driver, because they simply don't say it. I mean, if he had said Anderson Dupiton was with me or in another vehicle who was able to see the driver and positively identified him as the driver, then that would be a different story. But this just says a vague statement that they were able to connect him as a possible driver, and then someone else identified him.
It seems like a great argument and a motion to suppress. I'm trying to figure out why there's not probable cause. It's cause to believe your client probably did it, right? That's probable cause.
Right, but there's case law that says that conclusory statements are not enough. And in this case where they said he's a possible driver, but he doesn't explain why. He doesn't say the driver has hair that looks like him, or, he's a registered owner of the vehicle, or, anything to connect him to the vehicle, just that he's a possible driver. So it's not supported by any articulable facts that would support probable cause.
Do you have any case law to support that argument, Counselor?
I'm sure I could find some, but, obviously probable cause must be supported by articulable facts, not just a hunch. And in this case, I assume the court's familiar with that case law that says that it must be more than a hunch. And this.
But the deputy was able to positively identify Daquan as the driver. That's not a hunch, that's a positive identification based on fact.
But what facts? That's the problem, is that we don't know, and the independent magistrate cannot make a determination of whether there's actually probable cause based on what they've said.
I have to make a determination of probable cause based on what they've said.
Right, but they haven't given you enough facts to actually evaluate the facts for.
He was able to positively identify Daquan as the driver.
And how? I understand that it says that, but it doesn't say where he saw him, when he saw him, it doesn't even say whether he saw him. It just says he was able to identify him as the driver. And the state made the argument that they're familiar with him. Perhaps, I don't know anything about that, but we don't know if he just described someone and the other.
I showed the deputy Daquan's photograph, so he showed him his photograph, didn't describe him. Based on the photograph, he was able to positively identify Daquan as the driver of the vehicle.
I know.
It doesn't look like a hunch, it doesn't look like. It looks like a law enforcement officer was able to identify your client as the driver of a vehicle that was fleeing or attempting to elude law enforcement. That there's cause to believe your client was probably the driver, since the law enforcement officer could positively identify him as the driver. Trying to get there. Do you think that if we pass this case, you can give me some case law that supports your argument?
Yes, if I could have a few minutes.
Yeah, if you have a few minutes, we'll just pass this case and bring him back up.
Thank you.
Thank you. All right, let's see if we got Judge McGinnis. Just a moment. Please tell me your, oh, hold on.
Good morning. This is Talia Romero, Spanish interpreter on the line, already sworn in today.
Please connect with the headset.
Yes, one moment, Your Honor.
Sí,
He can hear the interpreter, Your Honor.
Please tell me your name.
Osvaldo Rivera.
Osvaldo Rivera.
Yes.
21 MM 4557, you're here charged with trespass on property after warning. There is probable cause. Did the state have an offer?
No,
Yes, Your Honor, it is a adjudication of guilt, credit time served, no return to the Belmont Plaza, which is at 3020 North Goldenrod Road.
Mr. Brandt, did you have an opportunity to discuss this with him?
Due to the language barrier, Your Honor, I did not. I have a Spanish plea form that I had filled out for him. If he is able to review that, I'd also like to inform him that if he's not a U.S. citizen or if he's on probation, entering a plea could be used to deport him or to violate.
All right, sir, can you read that form?
no estoy probatorio. No, yo no veo bien.
No, I'm not able to see clearly.
All right.
Yo soy ciudadano americano.
I am a U.S. citizen.
The state has offered you, if you are interested in pleading guilty or no contest, an adjudication of guilt, credit for the days that you've been in jail, and that you wouldn't be allowed to return to the scene. Are you interested in doing that today?
Okay.
Your Honor,
Sí.
I believe there's also an offer of withhold and credit time served on his out on bond case 21MM1473, if state could confirm that.
I'm not going to do that. He's got a prior conviction. I'll adjudicate him and give him credit, but I won't withhold.
Even on the out on bond case, Your Honor?
Yeah, he's got a prior conviction for trespass.
Is it the same property?
I don't know. I just have the history.
Okay.
All right, please raise your right hand, sir.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Sí, señora. Sí, sí, señora.
Yes. Yes, ma'am.
Okay, put your hand down. I need to make sure that you understand the rights you're giving up if you enter a plea of guilty or no contest today. You're giving up your right to remain silent, your right to a jury trial when one is required, your right to testify on your own behalf, your right to call witnesses and present any defenses you may have at trial, your right to force the state to prove the charges against you beyond all reasonable doubt. You understand that if you enter a plea of guilty or no contest today, you're giving up all of those rights.
Yo, sí, señora, yo me declaro culpable.
Yes, ma'am. I do plead guilty.
All right, do you have any questions for me about the rights that you're giving up before I accept your plea?
Your Honor, if I may, the withhold of adjudication on the out on bond case
No hay pregunta, doña.
was an
No question,
offer
ma'am.
from the state.
I understand that. The state can't offer a withhold. The state can recommend and ask the court to withhold adjudication, but they can't offer it. Adjudication is in the hands of the court.
Oh, gracias.
But is he aware that this is going to be 2 convictions as opposed to just 1?
It's an excellent thing to advise him of, counselor.
Are we appointed, Your Honor?
I'll appoint you in both cases. Oh, I think you were in the first one.
Pero no entiendo.
Counsel, he does not understand.
There's 2 cases of trespass right now. The plea would be 2 convictions, one for trespass in the past and one for trespass today.
So do you understand that you have 2 separate cases?
Sí, señora.
And you can enter
Yes,
a
ma'am.
plea for one case and wait on the other one, or you can enter a plea for both cases today, but they would both result in 2 convictions.
Yo la acepto.
I accept that.
And you've had time to review the plea form in front of you?
He can't read it. He said he can't see.
No. Ve,
You don't have glasses?
poquitos.
Little.
I would prefer if he read the plea form before entering a plea today, Your Honor.
He can't do that, counselor. He can't see it.
At a later date, I suppose, when he can get his glasses.
I'm sorry, what?
If he has glasses, he doesn't have his glasses, he can't read it. So he might be giving up rights he's not aware of because he couldn't read the plea form.
Which rights have I not gone over with him that you're concerned he is not aware of?
I can't answer that. I just think that pleas are being rushed in. I was under the impression he would have one withhold and one adjudication of guilt, but I'm uncomfortable.
Counselor, there are no
Okay.
pleas being rushed in this courtroom, and you have access to your clients an hour and a half before
I
court.
understand, but if I
It's
don't have an
incumbent
interpreter, I
on
can't
you
speak to
and
him.
your office to meet with your clients before court if you'd like to do that.
If we aren't appointed, we don't have to speak with them. We do that as a friend of the court. Also, if I don't speak Spanish, so I can't speak to him anyway.
Then
I
you should
tried
talk to
speak
your
him.
office about getting a Spanish interpreter for you,
And I
counselor.
attempted to talk to him, and he said he only spoke a little English, and so I decided to use the interpreter in court. And now the terms of the offers have changed. And
No
so
terms of any offers have
The
changed.
state offered withhold and credit time served, and you're refusing that offer, which I
The
understand.
state can't offer a withhold, counselor. That is in the purview of the court.
I understand.
The state can make a recommendation, and the court is not bound by any offer that the state makes ever in any trial court. You understand that?
Yes.
Sí.
Now, Mr. Rivera, you have three options today. You can enter a plea of not guilty. We'll continue these cases to be heard at a later time. You have the right to a trial by jury, if that's what you want. Your attorney
No, yo me quiero declarar culpable de aquí de los dos casos. Sí, señora.
I want to plead guilty here to both cases.
You can plead no contest to both cases as well.
You can plead guilty or no contest. A plea of guilty accepts responsibility for what you've done. A plea of no contest tells the court that while you're not admitting guilt, it's in your best interest to enter a plea today. Do you have any questions for me about the rights you're giving up by entering a plea of guilty today?
Ya. Sí, señora, yo entiendo. Me declaro culpable.
Yes, ma'am, I understand. I'm pleading guilty.
Very well, Your Honor. That's his wish.
I'm sorry?
Very well, Your Honor. If that is his wish, I'll sign his plea form.
All right, Mr. Rivera, at this time, how do you wish to plead to the charge of trespass on property after warning?
Has he been sworn in, Your Honor?
Yes. In 21 MM 4557.
Culpable.
Guilty.
And 21 MM 1473, how do you wish to plead to the charge of trespass on property after warning?
Culpable.
Guilty.
I'll accept your pleas of guilty. I find they're freely and voluntarily made. I'll adjudicate you guilty in each case, give you credit for the time that you've been in jail. You have 2 days on both of those cases. I'll order that you're not allowed to return to, does the state have the address?
Yes, Your Honor. 3020 North Goldenrod Road. It's the Belmont Plaza.
All right, you understand that, sir. You can't go back to the Belmont Plaza.
Yes.
All right, good luck, sir. You have 30 days to appeal in writing. Oh, I have to order that you pay court costs. I'll give you a year to pay them. Good luck, sir.
Y yo, señora, yo, ¿cuándo saldría hoy?
Ma'am, when would I get out? Today?
Yes, sir. Unless there's anything else holding you on these cases, you'll be released today.
No tengo más ningún caso.
I don't have any other cases.
All right. Have a nice day then. Good luck.
Gracias.
Thank you.
Sir, please tell me your name.
Carlos. Carlos. Torrosa. Torrosa.
Carlos Torrosa.
Sí.
21MM270, you're here charged with battery. There is probable cause in this case, and I'll appoint an attorney to represent you. You're not allowed, your bond is $500. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Sí.
Yes.
You can't possess a weapon, firearm, or ammunition. I'll order you must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you may not coordinate that with the victim. Do you understand?
Okay.
Oh,
Did I say no weapons?
yes.
All right. Good luck, sir.
¿Saldría hoy o
Wait,
Would I get out today?
saldría?
you have to post bond, so that's up to
Can I
you.
get-
Okay.
Okay.
Good luck.
Gracias.
Thank you.
Is that all for the interpreter? Okay. Sir, please tell me your name.
Liber Saurida León. Liber Saurida León.
Aníbal Sabrina León.
You have 3 capiases that were issued for your arrest. In 21 CT 2563, a capias was issued for you for failing to appear for arraignment on a charge of operating a motor vehicle without a valid driver's license. There's no bond authorized on that capias, and I'll appoint the Public Defender's Office to represent you. In 21 CT 2564, a capias was issued for your arrest for failing to appear for arraignment on a charge of knowingly and willfully abusing or misusing a temporary tag. There is also no bond on this case, and I'll appoint the Public Defender's Office to represent you. In 21 CT 240, you're here charged with no valid driver's license because a capias was issued for your arrest when you failed to appear for your arraignment. The bond authorized on that case is $2,000, and again, I'll appoint an attorney to represent you. Good luck, sir. Is that all we have for interpreter cases?
Yes, Your Honor.
All right, thank you.
Thank you, Your Honor.
All right, Counselor, we're back.
Yes, Your Honor. Chelsea Simmons.
21 CF 7796.
Chelsea Simmons for Mr. Phillips. I don't think I'm going to be able to find anything that's exactly case specific or fact specific on point in the time that I have, but I do have the case law that discusses conclusory statements. I can email a copy to the court. I sent a copy to the state already.
Can you print that out, Madam Prosecutor?
I have not received it yet, Your Honor.
Oh,
Oh, I do have pretty bad Can you? Maybe I spelled it wrong. Can you tell me your email address?
Yes, Beugene, Beugene @sao9.org.
Okay, I sent it. was still asleep this morning and sent it to .com, but.
So it's floating out there somewhere.
I just got it, Your Honor. Now the fun begins. Your Honor, I apologize. I am not seeing this printer as an option for me to print to. I apologize. That's just a technical issue. But I do have it. I could bring my computer up there if you'd like to see it on my screen.
Can she send it to you to print? Ooh, send it to the clerk. They can print it.
Okay. Thank you.
Well, sometimes technology is your friend and other times it's not.
Just sent it.
While they're working on printing it, Counselor, what, you think that this case law applies to the two sentences we've been discussing?
Well, Your Honor, this, like I said, I can't find something that's exactly case-specific, but, or factually similar. But this case is discussing, basically it says that wholly conclusory statements fail to meet the probable cause requirement. The reviewing magistrate cannot abdicate his or her duty and become a mere ratifier of the bare conclusions of others. And then they cite to a U.S. Supreme Court case of Gates. The case I'm reading, just for the record, is Burnett versus State, 848 Southern 2nd, 1170. And then it cites to Illinois versus Gates, Illinois versus Gates, which is 462 U.S. 213. And then further down in Burnett, it states that to determine probable cause, the magistrate is required to evaluate whether the case-specific facts yield a legal conclusion that probable cause exists. Here, the affiant's education and experience in matters of child pornography were not set out, nor did the affiant indicate the degree of commonality that is alleged to exist. Although it may not be unusual for suspects such as Mr. Burnett to retain child pornography images, the question is factually to what degree that propensity could be attributed to him. This is, again, very different from the case at hand factually, but the case law is brought to the court's attention to illustrate the fact that this conclusory statement is similar to the one here, where there's no facts to support that conclusion for the court to determine whether probable cause actually exists or not.
All right, so I'm on the second to last page. In paragraph 7, the affiant described her belief in the generalized behavior of other persons who receive or transmit images of children and who are unable to erase the contents of their computer. From this generalized information, which contained no link to criminal conduct by Mr. Burnett, the officer concluded that it contained it, and that was the error.
Yes, Your Honor, and the next sentence says probable cause analysis focuses not on the evidence that is found as a result of this. Well, I'm sorry, obviously, this case is more about propensity between types of offenders, and in this case, they are trying to argue that Mr. Phillips was fleeing because he has a previous conviction for fleeing, but that is not accurate.
I don't see that in the affidavit. So I don't think it matters that they noted he has a prior conviction for fleeing or eluding. I don't think that's a propensity argument.
I thought that the court was relying partially on that.
I'm not. I don't think that's relevant to the probable cause determination. That's why I said earlier, I think you have some great arguments for some other motions, but I don't think that's relevant for probable cause. What I'm trying to get to is it looks like in this case that you've provided the court, the affiant made generalized statements about other people. So I would liken that to in the instant case, if the officer had said, typically when we have cars like this Alfa Romeo who flee from us, the driver looks like him or they do this thing, then I think that's more analogous to the case. But in this case, we have one law enforcement officer who is able to identify him as possibly the driver and a second one able to positively identify him as the driver. So it doesn't sound like generalized statements. It sounds like you have law enforcement officers who saw him driving because they identified him as the driver. It says positively identified him.
Right, so like I said, this case, Burnett, is not factually similar to this one. My reason in bringing it to the court's attention is the language and the holding that wholly conclusory statements are not enough for probable cause. This statement...
Direct me to that language really fast, please. I think you did earlier, but I was reading.
Yes, it's right above Head Note 3 in the paragraph that begins Illinois versus Gates. Halfway through that paragraph, as stated in Gates, wholly conclusory statements fail to meet the probable cause requirement. The reviewing magistrate cannot abdicate his or her duty and become a mere ratifier of the bare conclusion of others. So my argument here is that this statement, that he identified this person without any supporting facts on how he was able to see this or how he was able to identify the person, is a wholly conclusory statement that the court should not just rubber stamp, that would need to analyze other facts to determine whether probable cause actually exists. If it were the officer who wrote the statement, who said, I tried to pull him over and I saw him and I compared him to his photo and I positively identified him, then I would not have an argument. But he's bringing in another officer who's not mentioned. None of his actions were noted in the report. We don't know anything about this other officer or how he was able to make a positive identification.
Using law enforcement databases is not sufficient?
Well, that was to lead to a possible driver, and also I'm not sure. They also don't explain that either. If they had said he's a registered driver or he's connected to a registered driver or something more, we don't know how his name came up as a possible driver.
Well, later it says the above mentioned address is Daquan's current address of record through using David. So it does say that later.
Well, that address is just,
It's where they
that has
found
not,
him.
I don't see where that connects to the car. Later, they see,
Well, it's where they found him, but because it says
but it
it's
doesn't.
his address in David.
Sure, it doesn't say that that the car is registered at that address, unless I missed it somewhere. And then they see someone else entirely driving the Alfa Romero, and Mr. Phillips is in a Mercedes. So that's way later, though. First they're saying that they connected him as a possible driver, and then they see him near the vehicle on a different day in a different area. So none of this adds up to probable cause.
To determine probable cause, the magistrate is required to evaluate whether case-specific facts yield a legal conclusion that probable cause exists. The magistrate's duty is to examine the affidavit for facts and fact-based conclusions. An affidavit is not limited to the affiant's personal knowledge. In some instances, information from confidential informants or scientific evidence can be presented, et cetera, et cetera. Does the state have any argument?
The only other thing I would note, Your Honor, is that there were times when the driver actually made right turns, and I believe that would also afford the officers the ability to see the driver clearly as opposed to just being behind him. I also believe that it is enough that they pulled a David picture. One officer believed it was him, and then it was confirmed by a second officer, Your Honor.
task of the issuing magistrate is simply to make a practical, common-sense decision, whether given all the circumstances set forth in the affidavit before him, including the veracity and basis of knowledge of persons supplying hearsay information, there is a fair probability that contraband or evidence of a crime will be found in a particular place. Including the veracity and basis of knowledge of persons supplying hearsay information. So, Deputy Saboteur's observations combined with Deputy Dupitin, taking all of those facts together, given all of this information, you still don't think there's cause to believe your client was probably the driver of the car that fled or eluded?
Judge, I have no additional argument.
Okay.
Yes.
It is a fantastic argument. Do you know what the negative treatment is for of this case, Burnett?
It says it was disagreed with by People versus Nichols, which is a California appellate court, is what it says on the top of the page. And then,
I'm assuming it's not this issue, because I think you'd have noticed that.
right, I mean, there's three cases. One is saying that the magistrate was not required to conduct a FRI hearing before deciding probable cause. I mean, that's obvious.
Right.
And a different one regarding a search warrant where the affidavit provided probable cause for the issuing judge to reasonably infer that the defendant intended to assemble a firearm, but that's a Connecticut case. So 2 out-of-state cases that are disagreeing with Florida law.
All right, thank you. You have a fantastic argument. I think you almost persuaded me. However, I still think there's probable cause here. But what I'm going to do is, instead of requiring your client to post a $15,000 bond, which is typically what I do in these cases, I'm going to reduce that amount significantly. So, sir, your bond will be $1,000 on count 1 and $100 on count 2. You can't possess or consume any controlled substance without a valid prescription. You can't drive without a valid Florida license. Hold on 1 second. All right. Good luck, sir. And you should thank your attorney. She did an excellent job this morning. Thank you, counselor.
Thank you, Your Honor. Have a good weekend.
You as well. Happy 4th. Please tell me your name.
Ralph Gallo, can you hear?
Yes?
Ralph Galoza.
21MM4559. You're here charged with resisting an officer without violence. There is probable cause. Did the state have an offer in this case?
Yes, Your Honor, it was a withhold of adjudication and credit time served.
I did have a chance to speak with Mr. Galoza in the back, Your Honor. And considering his very slim history, 2 unknown cases, I think PTR reports, I would just have you set a bond on this case, Your Honor.
Your bond is $500. All right, good luck, sir. And I'm appointing the public defender's office.
Thank you, Your Honor.
Please tell me your name.
Shavia Hickman.
21MM4561. You're here charged with resisting an officer without violence and retail petty theft. There is probable cause in this case. I'll appoint the Public Defender's Office to represent you. Your bond is $500 on count 1, $250 on count 2. You're not allowed to return to, is this the mall?
I think the address was Zara 8001
8001, yeah.
Orange Blossom Trail. I think it is a,
Is that the Florida Mall? It is, Your Honor. All right, you're not allowed to return to the Florida Mall. Do you understand that?
Yes, ma'am.
Your Honor, as to the I don't believe she's out on bond on that case, 21MM3188. I believe she was issued a summons on that, and there hasn't been a complaint. There's been an information filed, but there's no complaint with facts. So I would have you take no action on that, Your Honor.
Is that right, Madam Prosecutor?
A moment, Your Honor. That is correct, Your Honor. At this time, well, no, there's a pretrial conference set for July 22nd, Your Honor.
But she's not out on bond. There are no release conditions to revoke. Is that
No.
right?
I believe so, Your Honor.
All right, good luck.
Oh, thank you.
Please tell me your name.
Tyler Michael Bohinski.
21 CF 7808. You're here charged with tampering with a witness to hinder communication to law enforcement and battery domestic violence. There is probable cause. I'll appoint an attorney to represent you. Does the state object to pretrial release in this case?
No, Your Honor.
At this time, I'm going to place you on pretrial release with special conditions. You can't have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow one-time return with law enforcement to gather your belongings, but you cannot coordinate that with the victim. Do you understand?
Yes, ma'am.
All right, good luck. #21 CF 7801. Counsel, I'm going to appoint your office.
We'll waive the appearance, Your Honor. Move my phone.
There is probable cause in this case. Bond will be $15,000 on count 1, $5,000 on count 2, no victim contact, no weapons, firearms, or ammunition. Maintain a separate residence, one-time return with law enforcement. Please tell me your name.
Robert E. Jones Jr.
21 CF 7773. You're here charged with aggravated assault, domestic violence. There is probable cause in this case, and I'll appoint.
As to the probable cause determination.
Whoa. I don't know what's happening. Yes, go ahead, Counselor.
This is Robert Jones.
Yes.
I was reading the arrest affidavit. I believe I don't know if this is a co-defendant or the alleged victim, but she was the one with the gun the whole time. I don't believe there were any facts that indicated that he had a weapon of any kind other than the facts that stipulated he may have allegedly spit on her. So I wouldn't have you find PC for aggravated assault as there's no facts that indicate they had a gun or that the weapon or anything like that to charge the aggravated.
What says the state?
I believe that is correct, Your Honor, that it is Miss Allen, I believe it is, who had the gun. Devin Nathan, I apologize.
I would have you find PC for simple battery, Your Honor, and then he also does qualify for PTO.
I don't think battery is a lesser included of aggravated assault.
Then I would have you release him on ROR. Sorry.
So an independent witness came forward who wishes to remain confidential under Marcy's law and stated that today a black male pulled up to the house, started arguing with the lady, then shot at the house. She stated she saw him leave with a black handgun. So that's why the court found probable cause.
Just a moment, Your Honor. I mean, the facts stipulate that the co-defendant was the one that shot the firearm. Did Angela?
There are no stipulated facts, counselor. The victim slash co-defendant in her statement says that, but keep reading.
Yes, an independent witness came forward, Angela Winchester, which is to remain confidential under Marcy's law, stated that today. Black male pulled up to the house and started arguing with the lady and then shot at the house.
So the independent eyewitness in the probable cause affidavit says that he's the one who shot the gun.
Even though the rest of the affidavit stipulates that it's the co-defendant that had the gun.
There are no stipulated facts, counselor. There are statements by witnesses in a probable cause affidavit. So the victim slash co-defendant doesn't say that, but another witness does.
The state agreed with me as well.
Your Honor, I do apologize. I did not see that independent witness. I do apologize. No, I believe that he too should be charged. It's appropriate.
There is probable cause.
Yes, Your Honor.
Law enforcement even collected the casings. Your bond is $5,000. You're not allowed to have any contact with the victim. Do you understand what no contact means? You're not allowed to have any contact with the victim. Do you understand what no contact means? I see a note here that says you have a prior aggravated stalking case with this same victim. There is also an active, although not served, injunction for stalking with this victim. So I want to be really sure that you understand what no contact means.
Yes, ma'am, I do.
You can't speak to her. You can't send her a text message. You can't call her on the phone. You can't be within 1,000 feet of her place of residence or employment. Do you understand that? You can't send a message through friends or family members. You can't contact her on social media. This is no contact at all.
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. I'll order you have to surrender this firearm to law enforcement within 24 hours of your release. You must maintain a separate residence. I will allow one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. You understand that?
Yes, ma'am.
You can't have contact with the witness in the case or be within 1,000 feet of her residence either. Do you understand? All right, good luck, sir.
What was the bond amount, Your Honor?
5,000.
Man, chase.
21 CF 7798, I find his refusal to come to court a willing waiver of his appearance today. There is probable cause in this case for aggravated battery.
Your Honor, as to the PC on this case as well,
Hold on, I'll appoint you to represent him. Go ahead, counselor.
I didn't find that the phone calls, there were complaints by phone. None of them were listed. And no statements were taken from those calls. I wouldn't have you find PC on that charge.
The charge is aggravated battery.
I
Your
understand.
Honor, it says Klein was seen grabbing Heaven's arm and was seen punching Heaven in the face.
I don't understand the argument about the phone calls, counselor. What do you mean?
There's no names no witness testimony, just the phone calls. And then the police arrived. And, other than the phone calls, there wasn't any witness testimony. The two parties didn't stipulate that there was, or didn't state that there was a battery. Just these anonymous phone calls.
So the fact that law enforcement received several phone calls with complaints and they get there and the victim is bruised and bleeding, you don't think that's enough for probable cause?
That Mr. Klein did the battery? I don't believe so, no. If the calls had been named, if they were named callers in the affidavit and they had included their statements, it would be a different story, but it is your determination.
What says the state?
Your Honor, in those statements, they say Klein was seen grabbing Heaven's arm and was seen punching Heaven in the face. That is enough for a battery, Your Honor.
I do find probable cause in this case. His bond is $10,000, no contact with the victim, not returned to Church's Chicken, maintain separate residence, one return with law enforcement, no weapons, firearms, or ammunition. Not allowed to possess or consume controlled substances without a valid prescription. Please tell me your name.
Devin J. Nathan.
21 CF 7774. You're here charged with aggravated assault with a firearm, domestic violence, and battery, domestic violence. There is probable cause in this case. I'll appoint an attorney to represent you. She qualifies for pretrial release. What says the state?
Your Honor, considering that there was a firearm that was actually discharged, I would ask for bond as well, but barring that. And then also, of course, no firearms, no weapons, ammunition.
Yeah. All right, I'm going to place you on pretrial release and also require that you post a monetary bond. However, I'll reduce that amount significantly. Your bond on count 1 will be $1,000, and on count 2, it'll be $100. You can't have any contact with this victim/co-defendant. You understand that?
Yes.
You can't possess a weapon, firearm, or ammunition. You two have to maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings, but you can't coordinate that with each other. You understand that?
Yes.
You can't have contact with any witness in this case. Any other conditions the state would request?
No, Your Honor.
Good luck, ma'am. Please tell me your name.
Tyler Vance.
In 21 CF 7809, you're here charged with possession of cocaine and battery dating violence. I'm going to appoint an attorney to represent you. Counselor, did you wish to be heard in this case?
Not this time, Your Honor.
All right, there is probable cause. Your bond is $1,000 on count 1, $500 on count 2. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow one-time return with law enforcement to gather your belongings. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. In 20 CF 2877, a warrant was issued for your arrest, charging you with burglary of a dwelling with assault or battery with a firearm, aggravated battery, aggravated assault dating violence, aggravated assault with a firearm, possession of a firearm by a convicted felon, possession of ammunition by a convicted felon, and resisting an officer without violence. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Did the state wish to be heard as to bond on count 1?
That, Your Honor, is a PBL, and I would ask for no bond.
No argument, Your Honor, pending an Arthur hearing.
All right, at this time, you'll be held at no bond on count 1. Your bond on count 2 will be $10,000. Counts 3 and 4 will both be $5,000. Count 5 and 6 will both be $4,000. Count 7 is $100. You can't possess a weapon, firearm, or ammunition. Do you understand that? You can't have any contact with the victim or any witness in this case. You can't return to this residence for any reason. You can't have contact with any, did I say witness?
Yes.
Witness. And I'll order you have to surrender any firearms to law enforcement within 24 hours of your release. In 21 CF 7428, another warrant was issued for your arrest, charging you with domestic battery by strangulation. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Your bond is $15,000. You're not allowed to have any contact with the victim. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. I'll order you must maintain a separate residence and allow a one-time return with law enforcement to gather your belongings. Good luck.
Just a moment to confer, Your Honor.
Please tell me your name.
Teresa Denmark.
21MM4558. You're here charged with battery domestic violence. There is probable cause, and I'll appoint an attorney to represent you. Any objection to pretrial release?
No, Your Honor.
At this time, I'm going to place you on pretrial release with special conditions. You can't have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. Do you understand?
Yes, ma'am.
Good luck.
Thank you.
Please tell me your name.
Jose Caraballo.
20 CT 3539. You're here because a capias was issued for your arrest for failing to appear for a violation of probation status hearing on a charge of DUI. There is no bond authorized, and I'll appoint an attorney to represent you. Good luck.
Okay.
Please tell me your name.
Jennifer Brown.
All right, let's do that one. 21 CF 7799 and 7810. I'm going to appoint your office, Counselor. Do you want to waive his appearance?
Waive the appearance, Your Honor.
All right, there is probable cause. I'll stay the bonds, 15,000 on the possession of methamphetamine with intent to sell, 1,000 on possession of controlled substance. He's not allowed to possess or consume any controlled substance, have contact with any known drug dealers, or have any co-defendant contact.
Your Honor, I only see the charge of methamphetamine.
I can't hear you, what?
I only see the charge with possession of methamphetamine with intent.
You don't see it?
No, I only see the one charge.
Only see that he has one charge, Your Honor.
So I have 2 probable cause affidavits.
Lawrence Adams?
Oh, that's a different name. It's just attached to this one.
I believe there were 3 defendants in this case.
Is that someone else that's here today? Do you know? Okay, hold on a second. No, next is Jennifer Brown. Hold on. Oh, all right, well, somehow it was attached. All right, so just 21 CF 7810 then. Same conditions. Thanks for catching that. Please tell me your name.
Jennifer Brown.
A capias was issued for your arrest in 21 CF 7527 because an indictment was filed charging you with death caused by unlawful distribution of fentanyl. I'll appoint an attorney to represent you. There's no bond authorized on this. Does the state have access to the indictment? I need to know the dates of the alleged incident. Because I show that she's out on bond in several cases, but I don't have access to the date.
One moment, Your Honor.
This is a false charge.
Fourteenth day of September, 2020,
Is what?
September 14th, last year.
Is the date of the alleged incident
Yes, Your Honor.
that's charged?
Yes, Your Honor.
Okay.
Leave all the out-on-bond cases.
I think they're 21. All right, so I'll take no action. She's not out on bond in those. Good luck. Please tell me your name.
Pedro Luis Castro.
18 CF 1940. A capias was issued for your arrest for failing to appear for a status hearing on charges of possession of oxycodone and possession of cannabis less than 20 grams. There is no bond authorized, and I'll appoint an attorney to represent you. Good luck.
Thank you.
Please tell me your name.
Heather Cross.
20 CF 3859, you're here because a capias was issued for your arrest for failing to appear for a pretrial conference on a grand theft of a motor vehicle. Your bond is $2,500, and I'll appoint an attorney to represent you.
Yes, ma'am.
Good luck. Sir, please tell me your name.
Steven Sandor.
You're here in 21 CF 7813, charged with aggravated battery on a law enforcement officer with a deadly weapon, aggravated assault with a deadly weapon, principal, aggravated assault with intent to commit a felony with a weapon, resisting an officer with violence, throwing a deadly missile into an occupied vehicle, and assault on a security officer. I'm going to appoint an attorney to represent you. Did you wish to be heard, counselor?
The defense, Your Honor?
Yes.
But the only issue I had was, one of the charges was a detainer. I'm double checking to make sure about his bond status, if you could give me a moment.
I'm not a detainer case. I'm just talking about this one.
Okay, yes, I don't need to.
I think there's probable cause. I was just giving you the opportunity if you saw something I was missing. All right, sir, there is probable cause in this case. Your bond is $10,000 on count 1, and then $150 on counts 2, 3, 4, and 5, $100 on count 6. You can't possess a weapon, firearm, or ammunition. Do you understand?
Yes.
Are you talking about his out on bond case or something else?
Well, on this sheet, it had it as a current charge, but it was just an out-of-bond
His
case.
case was endorsed by the bondsman.
2021 CF.
Out-on-bond case was endorsed by the bondsman.
All right. Good luck, sir.
Are you taking no action, Your Honor?
Yeah. Please tell me your name.
Daniel Egley.
21 CF 525, you're here because a capias was issued for your arrest for failing to appear for arraignment on a charge of petty theft with 2 prior convictions. There is no bond on this, and I'll appoint an attorney to represent you. Good luck, sir. Jordan bonded. Please tell me your name.
Jessica Jones.
21 CF 7763, you're here charged with possession of cocaine and possession of drug paraphernalia. There is probable cause in this case, and I'll appoint an attorney to represent you. Your bond is $1,000 on count 1, $100 on count 2. You're not allowed to possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. I show that she's on probation, so a violation of probation might be pending. Good luck, ma'am.
Did you say 100 on the second?
I did.
Okay, thank you, Your Honor. Sorry about that.
Please tell me your name.
Stephen Kelly, ma'am.
21 CF 7766. You're here charged with burglary of a conveyance, possession of burglary tools, battery, and petty theft. There's probable cause in this case, and I'll appoint an attorney to represent you. Your bond is $3,500 on count 1, $150 on count 2, $100 each on counts 3 and 4. You're not allowed to return to this scene for any reason. You can't have contact with any victim or witness in this case. You can't possess a weapon, firearm, or ammunition. Good luck, sir. Please tell me your name.
Nicole Kimberly.
A capias was issued for your arrest in 19 CF 15907 for failing to appear for a status hearing on charges of possession of cocaine, possession of drug paraphernalia, and petty theft of $100 or more. There's no bond authorized on this capias, and I'll appoint an attorney to represent you. Good luck.
Can I please be heard?
You can, but because this is a capias that was issued by another judge, I can't change it. I can't give you bond today. It's not closed. Well, I don't know. There's an active capias. It says you were supposed to have a status hearing on May 25th of this year on this case. Please tell me your name.
Dana McDaniel.
21 CF 7800. You're here charged with possession of cocaine and possession of drug paraphernalia. There is probable cause in this case. I'll appoint an attorney to represent you. Your bond is $1,000 on count one, $100 on count two. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand? Do you understand?
Yes.
Good luck. #21 CF 7385, a warrant was issued for his arrest. I'm going to appoint your office counselor. Do you want to waive his appearance?
Waive the appearance, Your Honor.
Another judge has already found probable cause. I'll set his bond at $15,000. Must comply with sex offender reporting requirements. I'm going to take no action on his out on bond case. Please tell me your name.
Christina Sanseverino.
I'm sorry?
Christina Sanseverino.
21 CF 7802. You're here charged with trafficking in methamphetamines greater than 14 grams and tampering with physical evidence.
Your Honor,
I'm going to appoint an attorney to represent you. Yes, counselor?
have you heard on the PC for
Yes.
trafficking charge? I know the facts say that it was found with her, but it's just a strange series of events where the cop put her in the patrol car. Hold on. The facts say she had some illegal substances on her person. They put her in the patrol car, and then they came back to her, and somehow 14.8 grams were found in the car. So she doesn't know where they came from, the officer doesn't know where they came from, and then that's where she's charged with that. So unless the state has some supplemental facts, it's just a strange series of events for me. I would have you find PC for possession, but not trafficking. Unless we know for sure, or have a sure sense that.
So the law enforcement officer advised that the drugs were not in his vehicle before she was placed in them, and then when she got out, they found the drugs.
But she doesn't know where they came from either. So someone's.
I mean, obviously that's her statement, but the facts are the drugs weren't there, she was there, the drugs were there.
But if she's handcuffed in the car, where's it gonna come from?
I don't know where she was keeping the drugs, counselor.
I don't know either. That's why
I don't even want to know.
I'm arguing the case. There are facts that stipulate that anything was on the items that would.
There are no stipulated facts. It's a probable cause affidavit. Law enforcement searched this vehicle. There's no drugs in the vehicle. They put her in the vehicle. They take her out. There's drugs in the vehicle. So there's cause to probably believe that your client put the drugs in the vehicle.
It's just the two statements. My client says that she doesn't know where it came from, and the cop says they don't know where it came from. I'm just making the argument, Your Honor. It's just a strange thing that they searched her, put her in the car. They searched her twice, I think. They searched her once, then they searched her again before putting her in the patrol car, found something, allegedly. And then this 15 grams, which just so happens to meet the threshold of trafficking in the statute, show up. It wasn't 10 grams, it wasn't 7 grams, it wasn't 20 grams, it was almost exactly the amount needed to charge trafficking. It just smelled. It is your determination.
Which I have to make based on facts. Tell me what facts are missing or present that do or do not establish probable cause. Not how you feel or what you think or what you suspect. What facts?
Probable cause is the totality of the circumstances.
Yes.
I'm looking at totality of the circumstances, you're looking at totality of the circumstances. We may come to different conclusions. Mine is that this is a strange series of events. The puzzle pieces are in a different order, and for you, it may be a different picture, but I'm just making the argument that they searched her, I think, twice, put her in the car, handcuffed. It's not a spacious place in the back of a patrol car, and then all of a sudden, almost the exact amount of what's needed to charge trafficking is found. And my client says he doesn't know where it came from, says he doesn't know where it came from, it's there. According to the affidavit, we can make assumptions, but the affidavit suggests that no one knows where it came from.
Counselor, I need you to look at the facts, not assumptions.
Exactly,
I'm looking at the facts that are alleged in the affidavit.
yes. Is anything I said conflicted with what's in that? Other than my strange feeling that it's the exact amount to charge trafficking, but other than that.
An inspection of the rear passenger seat once San Severino was removed from the vehicle revealed several plastic baggies, one of which was broken. They contained loose, white, powdery, and crystal rock-like substances that field tested positive for methamphetamines and cannabis.
And we don't know where they came from.
And the total amount of methamphetamines collected from San Severino from the beginning to the end of our interaction was 18 grams.
That's right. But the amount found in the car was 14.8 grams.
What says the state?
Your Honor, going with just the four corners of the affidavit, defendant was in the car by herself. There were no drugs before. After she got out, not only were there drugs, but the drugs were broken. So it's not as though the officer went to the vehicle, saw dust there, and didn't understand what it was. On the four corners, Your Honor, probable cause is here.
I do find probable cause exists. Your bond is $50,000 on count 1 and $1,000 on count 2. You can't have any contact with the co-defendant or any known drug dealers. Do you understand?
Yes.
You can't possess or consume any controlled substance without a valid prescription. Good luck.
We have Darius Smith. He refused court.
21 CF 7811. He's charged with trafficking amphetamines greater than 28 grams with a firearm, possession of methamphetamine with intent, possession of methamphetamine with a weapon, possession of a firearm and commission of a felony, possession of ammunition by a convicted felon, resisting without violence, possession of a firearm by a convicted felon.
If appointed, will waive his appearance, Your Honor.
I'm sorry?
If appointed, will waive his appearance, Your Honor.
All right, I will appoint you. You can waive it. I also find his refusal to come to court a willing waiver of his appearance today. There's probable cause in this case. His bond will be hold on one second. Wait. Is that a punishable by life offense, counsel? Count 1? I think it's just an F1. Is that right?
Trying to confirm.
Oh, no, it is. That's a life offense. No, I think it's an F1. The firearm does not make it a punishable by life. All right, his bond will be $250,000 on count 1, $150,000 on counts 2, 3, and 3, $4,000 on count 4, 5, and 7, and $100 on count 6. He's not allowed to possess a weapon, firearm, or ammunition, have contact with known drug dealers, possess or consume any controlled substance without a valid prescription, or have contact with any co-defendants. Please tell me your name. 21 CF 7778. You're here charged with possession of methamphetamine, possession of drug paraphernalia, possession of cannabis less than 20 grams, and resisting an officer without violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000 on count 1, $100 on counts 2, 3, and 4. You can't possess or consume any controlled substance without a valid prescription. Do you understand?
Yes, ma'am.
You also can't have contact with any known drug dealers.
Your Honor, may I approach?
Yes. And at this time, I'll take no action on his out on bond case. Good luck, sir. Please tell me your name.
Jason Throckmorton.
21 CF 7793. You're charged with possession of methamphetamine, possession of drug paraphernalia, and resisting an officer without violence. There is probable cause. I'll appoint an attorney to represent you. Your bond is $1,000 on count 1 and $100 each on 2 and 3. You're not allowed to possess or consume any controlled substance or have contact with any known drug dealers. Do you understand?
I do.
In 21 CF 7794, you're here charged with burglary of a structure. Again, I'll appoint an attorney to represent you. There is probable cause in this case. Your bond is $7,000. I'm going to make that $5,000. You're not allowed to return to Sonesta Suites or have contact with any witness or victim in this case. Do you understand?
I do.
In 21 CF 7804, you're here charged with burglary of an occupied structure and criminal mischief. Again, I'll appoint an attorney to represent you in this case. There is probable cause. I'll stay your bond at $10,000 on count 1 and $100 on count 2. You're not allowed to return to the Rosen Aquatic Center or have contact with any witness in this case. Do you understand?
I am not aware of this case, no, ma'am.
All right. State, can you put the factual basis on the record, please?
Your Honor, it appears that the defendant was seen on video while the business was closed. He remained there for 2 hours. He unlawfully entered through the rear door of the center, Your Honor, by removing a small metal plate. He also attempted to silence the alarm while he was there.
What's the name of the establishment, State?
The Rosen Aquatic and Fitness Center.
So that's why you can't go back to the Rosen Aquatic Fitness Center. Do you understand?
I understand that accusation.
I'm not asking if you agree with it. The only thing we're doing here today is I'm telling you whether there's probable cause and setting your bond conditions, but get in touch with your attorney as soon as you can, because they'll talk to you about any defenses you have and what your strategy is in all of these cases. But just because of this, I have to look at the probable cause affidavit. So there's probable cause to believe that you entered into that place where you were not allowed to be. And so that's what this case is at this time.
What's the when you say probable cause, is it an identity via the video? Is that the case?
Say that one more time?
She mentioned a video.
Yes.
Is that where the probable cause for it being me?
That's part of it, yes. And what will happen is if you talk to your defense attorney, they'll file a motion, they'll file a demand for discovery, and the state will have to send them all the discovery, which would include the video. So then you'll be able to watch that with your attorney.
May I ask, in backing up just a
Yes.
step, could you let me know what the probable cause is for the possession of methamphetamine and the drug paraphernalia?
Hold on one second, let me go back.
Thank you.
State, can you put the factual basis for this case on the record as well?
Your Honor, the law enforcement responded to 8480 International Drive in reference to a burglary to a hotel room. When they got to the location, they found a white male who was later identified as the defendant. Upon search, they found the defendant hiding in a cabinet. They did a secondary search of the room when the defendant was removed, and at that time they found a large glass pipe, also known as a crack pipe, and it was in the area where the defendant was hiding, Your Honor. And inside the pipe there was methamphetamine in the liquid form. It was presumptive field tested for meth and tested positive.
So that's the probable cause for those charges.
I don't understand, because those things weren't mine, so the room was.
So hold on. Everything you say is being recorded and can be used against you later. So today, we're just talking about probable cause, which is cause to believe you probably committed the crime with which you're being charged. But if you think you have some defenses, you want to talk to your attorney about that, because they can raise those in front of the trial judge and/or file a motion, talk to the state attorney's office. And in this case, it's what we call a constructive possession case. If you're found with something that's not in your hands, but it's near you, that's constructive possession. I don't know if the state's even going to file this charge. They may not. It's just probable cause today. So I think you probably have some great defenses. You want to be in touch with the public defender's office as soon as you can.
Thank you.
Yes, sir. Please tell me your name.
Warren Matthew.
Hold on. 21 CT 4706. You're here charged with driving while license suspended. There is probable cause. I'll appoint an attorney to represent you. Your bond is $500. You can't drive without a valid Florida license. You understand that?
Ma'am.
And then in 21 CF 7803, you're here charged with tampering with physical evidence and possession of cocaine. There's also probable cause in this case. I'll appoint an attorney to represent you. You can't possess or consume any controlled substance without a valid prescription. You can't have contact with any known drug dealers or with the co-defendant in this case. Do you understand? All right, good luck, sir.
What were the bond amounts on those two charges?
Oh, sorry. $1,000 and $150. Thank you.
And I apologize, Your Honor, on the Dwellers, what
It was $500.
Thank you.
morning.
Good morning. Please tell me your name.
Brittany Willis.
21 CF 7621. A warrant was issued for your arrest, charging you with child neglect. Another judge has already found probable cause in this case. I'll appoint an attorney to represent you. Does the state wish to be heard as to bond?
Not at this time, Your Honor.
If you give me a moment, Your Honor.
Yes.
Your Honor, can I approach?
Yes. All right, Counselor, did you wish to be heard as to bond?
Yes, as this charge is a felony of the third degree, I would have you keep the bond as, according to the bond schedule, within the range of 1,000 to 2,500.
What says the state?
Your Honor, I apologize. I will leave it at the discretion of the court, Your Honor.
All right, ma'am, I reviewed the affidavit, even though another judge had already found probable cause in this case. Based on the fairly heinous allegations in this affidavit, I'm setting your bond at $15,000. You can't have any contact with any minor child under the age of 18. Yes, ma'am. You have to leave your mask on.
What do you want to say? The reasoning for setting the high bond because of the facts in the arrest affidavit. She has been unemployed. Her criminal history has been unrelated to this case.
Except for the fugitive from justice arrest out of state. That's also relevant for bond.
Of course, Your Honor, but I would like to hear the reasonings for the record for the higher bond.
Well, other than the heinous allegations, the fugitive from justice out of another state, upon reading the facts here that are alleged in the affidavit, Counselor, this court is convinced that to balance the safety of definitely the named victim and the other other 5 children here, as well as the citizenry of Orange County, $15,000 is a very reasonable bond. You also can't possess or consume any alcoholic beverages while you're out on bond. Do you understand? You can't possess or consume any controlled substance without a valid prescription. You can't have contact with Bakari Edwards. Do you understand? You're going to have to maintain a separate residence from the victim, because you can't have any contact with her.
I believe it's her husband, Your Honor.
Not the victim. You mean
Oh, I thought you,
Bakari?
that's her husband's name, Your Honor.
Right. So she can't have any contact with him, though, right now?
And if they live together, they have to have separate residences.
Yeah, she has to do that.
Well, hold on.
She can't have any contact with him or the victim.
Just a moment. I understand, Your Honor, just a moment.
Co-defendant, but I don't know. Yeah. Victim, witness, co-defendant, all of them. All of them.
Thank you, Your Honor.
And I'll order that you must comply with any plan set in place by DCF. Any other conditions the state would request in this case?
No, Your Honor.
All right, good luck, ma'am. Please tell me your name.
My name is Felipe Junior Rodriguez Gautier.
A warrant was issued for your arrest in 19 CF 7723 for violating your probation by committing the criminal offense of trafficking in heroin, 28 grams or more, on or about September 23rd, 2020, and by failing to live without committing any new law violation, to wit, conspiracy to traffic in heroin, 28 grams or more. There's no bond authorized on this warrant, and I'll appoint an attorney to represent you. Good luck. Good luck. Please tell me your name.
George Gallup Rutherford Jr.
A warrant was issued for your arrest in 18 CF 17265 for violating your probation by failing to make restitution payments to Crawford Tire, by failing to make court cost payments, and by failing to complete 100 hours of community service. There's no bond authorized on this warrant, and I'll appoint an attorney to represent you. Good luck. Please tell me your name.
Julian Simmons.
A warrant was issued for your arrest in 18 CF 15204 for violating your probation by accessing the internet via your Apple iPhone after being instructed not to do that, and by accessing the internet again, on the phone. There's no bond authorized on this warrant. I'll appoint an attorney to represent you. Good luck. Just a moment. I have Franklin bonded. Please tell me your name.
Oscar Warby, ma'am.
You have a warrant out of Broward County. In 0211231 CF10 for violating sex offender probation. For violating probation by committing the offense of violating sex offender probation. There's no bond authorized on this warrant. I'll appoint an attorney to represent you.
I have an attorney, ma'am.
Okay, then I won't. All right, good luck, sir. We'll notify them that you're here. All right, so this is Mr. Taylor, right?
Yes.
Samuel Taylor.
Yes, ma'am.
Unfortunately, the other judge in this case, 19 MM 9583, is in court right now, and I've been unable to get in touch with him. Is it possible to bring him back this afternoon? I can see if Judge McGinnis takes a lunch break on his day and see if I can get in touch with him during the lunch break. All right, Mr. Taylor, we're going to bring you back this afternoon because since it's a capias that was signed by another judge, I can't change it, but we need it changed. So I'm going to see if we can get it changed today.
Okay, what am I qualifying for? A pretrial release, or are they going to give me a...
You don't. So it'll be a monetary bond. 'Cause he's not going to qualify for regular pretrial release, right?
Oh, can the state make me an offer? I want to plead guilty and see if I can plead out and get everything taken care of so I can know my sentence time.
I think we should reset till second session, Your Honor, in case the Judge McGinnis, you hear back from Judge McGinnis.
Yeah. Do you have any notes about mental health issues? Is that why?
I believe so, Your Honor. That may be one of the factors in both of those cases. I believe they're going through an evaluation process in those cases as well. I would have you hear what Judge McGinnis has to say, because I think those cases might be in front of him. I don't know if he has a...
He's got two cases?
There was a pretrial release case and a 2020 case, I think.
Okay, I did 4 months on both of those charges already, four and a half months or more.
So here's the thing, Mr. Taylor, and the state may make you an offer, but if anybody has concerns about your mental health, then we have to make sure that we do this correctly, because I don't want you to enter a plea to something if you're not able to understand what you're doing, because then later you might regret it, and I don't want to put you in that position. So let's take a break over lunch, see if I can get in touch with the other judge. In the meantime, we'll ask your attorney to keep working on this as well, because perhaps your office can file a motion to quash the KPS or something, and then maybe Judge McGinnis will sign that, and then we could change it. So we'll work on it over lunch, and I'll see you back this afternoon, okay?
Okay, thank you.
Yes, sir.
Might be getting out today.
I don't know the answer to that.
Okay, thank you. Thank you, sir.
Okay, so this one has to come back this afternoon. Is the state ready for 33-day motions?
I apologize, Your Honor, I thought those were done in the afternoon.
Oh,
I'm sorry, I don't have, I mean, I can.
well, I mean, it's all the same people, so. Let's start with Mr. Taylor. Welcome back, sir.
Judge,
I recognize you. I've seen you a couple of times today.
thank you.
You're here in 19 MM 9583. I spoke with Judge McGinnis when he was able to take a break. He was also on the bench today. And it is, excuse me. At this time, he's releasing you on your own recognizance on this capias.
Thank you.
But I need you to do two things for me.
Huh?
First, you have to stay in touch with your attorney. He's going to give you a piece of paper that has a phone number in it. I'm going to need you to call that phone number as soon as possible. Do you understand?
Yes, ma'am.
You've got to stay in touch with your attorney. Is there, I see that he has two. Are they both pending before me today?
Your Honor, I was looking up on those, the capias had been executed, I believe at the beginning of June, and the warrant in 2020 MM 3540 had also been served at the beginning of June. I think he's been in the interviewing process for mental health PTR since then, so I believe you're able to issue ROR on both of those as he's before you.
I don't have that case today.
Okay.
So if there is anything else that's holding you, your attorney is going to have to work with the trial court on that. I can't tell you right now what else is holding you. But on this case, Judge McGinnis is releasing you on your own recognizance. So what we'll do is I'll ask your attorney to follow up on those other cases. If there might be one or two others, and the Volusia County hold might be also active.
We did move to quash that capias, Your Honor, in the break. I also, just for further reference, I suppose, I have case law on modifying a warrant amount.
It's not a warrant, it's a capias, that's the issue.
I think it might still.
We'll address that in another case, because in this case, we actually did it, but hold on to that case law.
Okay.
Mr. Taylor, just make sure that you stay in touch with your attorney, okay?
Okay, I'm getting out today?
I don't know if you are or not. You might have some other cases that are holding you in custody.
Okay, so, but the two are taken care of today.
Well, no, you have one case, it's not taken care of, it's still pending. It's a trespass that's still pending as a criminal charge against you, but I've released you on your own recognizance, so you don't have to post a bail in that case, but it's not gone. So you've got to stay in touch with your attorney, because if you fail to appear for court, the judge will issue another capias for your arrest.
Okay, so what,
So it's not over yet.
what else would be holding me here?
You have two other cases, and I don't know if those are going to stop you from being released today.
Oh, okay.
Okay, so call the number on that green piece of paper and ask them to figure it out for you so that they can tell you when you can be released and what they have to file on the other cases if you're not released.
Okay, what's the charge? What charge?
I don't have them.
You know, what county are they out of?
There's one out of Volusia County.
Okay, I already been sentenced over there. I did the time. I just got released from there, and brought over here. So.
Okay, so that one may not be pending. That may not be holding you. Does anyone know what is the other one a trespass as well?
No, Your Honor, with regard to the 2020 MM 3540, he was arrested for felony battery and criminal mischief. He was, however, only charged with battery, misdemeanor, and criminal mischief.
All right, so that's still pending?
Yes, Your Honor.
Okay, so that's a misdemeanor charge of a battery and a criminal mischief. That case is not resolved. It is still pending. So you're going to have to call the attorney on that piece of paper and make sure that you don't miss any court dates.
Okay, but if that's not holding, I get out today?
I don't know. Do
Yeah.
you know if there's a hold on that?
Your Honor, the last actions I see is the warrant was returned served on June 8th, and I think that's when he arrived here. And then court minutes suggest he has a status hearing July 27th at 9 a.m. with Judge Jewett.
But he would have had a bond.
For evaluation.
There's a no bond on there, Your Honor.
There's a no bond?
It was a violation of condition of pretrial release. It was a warrant.
Oh.
Habeas,
And
With a
then
no bond.
If it's a capias with a no bond. All right, I think your attorney is going to have to file a motion in front of the trial judge in that case, so you need to call them right away.
But just a moment, Your Honor. I think the first appearance from that June 8th date, I believe you were presiding. Let me make sure. Yes, can I approach, Your Honor?
Yes.
May I?
That judge will have to change it. I mean, yeah. All right, you need to call the number on that paper, sir.
Okay, and they'll let me, for what?
So you're being held at no bond on the other charge. They're going to have to file a motion in front of the trial judge.
So, okay,
So call that number right away so that they can file a motion for you in front of, I think it's Judge Jewett.
and this is out of Volusia County?
No, out of Orange County.
Okay, so when is my next court date? Or-
I don't know that.
Can I have a bond set for the,
So that case has no bond at this time.
okay, all right, thank you.
All right, good luck, sir. Sir, please tell me your name. Oh, sorry. And it's not this one. I do.
Good morning. Good afternoon, Your Honor. This is Theodore Leal, Spanish interpreter. The interpreter has been previously sworn, Your Honor.
Please connect with a headset and make sure he can hear you.
Very well, Your Honor. Connected to the podium, Your Honor.
Thank you. Sir, please tell me your name.
Mi nombre es Nehemías López Martín.
My name is Enemias Lopez Martin.
21 CT 1153. You're here charged with no valid driver's license. There is probable cause. Was there an offer?
Yes, Your Honor, it was a withhold of adjudication and credit time served.
Were you able to discuss that with him, Counselor?
Your Honor, I had to wait for the interpreter in court. Let me just advise Mr. Martin that the plea form in front of him has a list of rights. I would have him look at the one that I highlighted for him. If he's not a citizen, a plea can be used to deport, and if he's on probation, it can be used to violate his probation.
All right, sir, please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Sí.
Yes.
Did you understand everything that Mr. Brantz just said to you?
No mucho, pero
Not much.
All right, so you're charged with driving without a valid driver's license. It's a criminal charge. It's a misdemeanor. The state's asking the court if you are interested in entering a plea of guilty or no contest to withhold adjudication and give you credit for the time that you've been in jail. However, if you enter a plea of guilty or no contest today, you'll be giving up certain constitutional rights. Are you able to read that form in front of you?
¿Dónde?
May you have a moment to read through it before?
I want to know if he can. He may not be able to read it. You know, we had one this morning who didn't have glasses.
Understood, Your Honor.
Sí,
Yes.
Take a moment and review that form, because then I want to speak with you about it. All right, sir, are you interested in entering a plea of guilty or no contest today?
no me pongo cargo.
No contest to the charge.
Okay, so before we do that, though, I need to ask you some questions to be sure that you understand the rights you're giving up. Do you understand the rights you're giving up as listed on that form?
Sí, un poco.
Yes.
So you understand you're giving up your right to a jury trial when one is required, your right to remain silent, also your right to testify on your own behalf, your right to call witnesses and present any defenses you have. You're giving up all of those rights if you enter a plea of guilty or no contest. Do you understand that? Is that a yes?
Sí.
Yes.
Further, if you're not a U.S. citizen, entering a plea of guilty or no contest to this charge today could subject you to deportation. Do you understand that?
¿Cómo dijiste?
Sorry, what did you say?
If you're not a citizen of the United States of America and you enter a plea of guilty or no contest, you could be deported.
Pero no más que quiero hacer una pregunta, no sé, quiero llamar a mis amigos para sacarme aquí, pues.
Yeah, the only thing is that I do want to ask a question because I want to call my friends so they are able to bail me out of here.
All right, so if you enter a plea of not guilty, I'll set a monetary bond for you and you'll be able to be released on that bond. Is that what you want to do?
Yes.
All right, your bond is $250. Sir, you can't drive without a valid Florida license. Do you understand?
Sí, si quieres, yo una vez lo pago. Yo tengo mi dinero, lo quitaron ya 250 traigo.
Yes, and if at all possible, I can pay today. I do have some money.
You can do that. Your bond, did I say what it was? Your bond is $250 and I'm appointing a public defender's office to represent you. Good luck, sir. We have no other cases for the interpreter? All right, thank you.
Welcome, Your Honor.
Thank you, Your Honor.
21 MM 4567, there is probable cause. I'll find his refusal a willing waiver of his appearance today. Counsel, I'm going to appoint your office to represent him.
Your Honor, he, according to our notes, has been found incompetent to proceed in his out on bond cases. I would have you consider that in your determination perhaps to take no action.
Yeah, I'll stay his bond at $500 in the instant case with a no return, and I'll take no action in the out on bond case.
Your Honor, good afternoon.
Good afternoon, Counselor. Please put your appearance on record.
Your Honor, Dominic Paul Sigorsky on behalf of Jason Richardson, who's standing to my right.
Hold on. It's what? I don't have that one. Give me a minute. Got it.
Your Honor, if I may, I just filed my notice of appearance plea of not guilty at 11:30 this morning. It's probably not within the system, but I did provide the clerk a copy of my notice of appearance, just for record purposes.
Thank you for doing that, Counselor. This is 21 CF 7775. Is this Mr. Richardson?
Yes, ma'am.
All right, sir, you're here because a warrant was issued for your arrest, charging you with trafficking in methamphetamine greater than 28 grams with a firearm, possession of cannabis with intent to sell with a firearm, possession of Xanax, possession of a firearm by a convicted felon, and possession of ammunition by a convicted felon. Another judge has already found probable cause in this case and set bond on each of these counts. Counselor, is there anything you wish to be heard on regarding this case?
Yes, Your Honor, we're asking that the court consider a reduction in the bond presently set. I would like to take some brief testimony from Mr. Richardson, and I just have some brief comments in support of that motion.
Please proceed.
Mr. Richardson has been sworn.
He is not.
Raise your right hand. Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, I do.
If I may, Your Honor. Mr. Richardson, please state your full name.
Jason Allen Richardson,
And what is your date of birth?
February 27th of 1973.
You are 48 years old?
Yes, sir.
Okay, Mr. Richardson, how long have you resided in the Orlando, Apopka area?
My whole life, 48 years.
Does your mother live locally?
Yes, sir.
What is her name and age, and where does she reside?
Her name is Helen Pender. Her age is 47, no, excuse me, 67, almost 68. I'm
And
sorry.
where does she reside?
216 South Lake Pleasant Road, Apopka, Florida.
How long has she resided in this area?
35 years.
Do you have a father that lives in this area? If so, what is his name, his age, and where does he reside?
Yes, his name is Robert Richardson. His age is, I think he's 70 now. I'm not too sure on that, but yeah, he's 2 years older than my mom.
Where does he
He
reside?
resides, not 100% sure on the address, but it's Eustis.
And how long has he lived in that area?
About since I was 13, so 35 years.
Do you have a brother that resides also in Eustis?
Yes, I do.
What is his name?
His name is Bobby Richardson.
And what is his age?
He is 13 years younger than me, so
How long has he resided at?
his whole life.
Okay, does he live there with his wife and with his son?
Yes,
Okay, do you have two aunts that live in Sanford?
yes, I do.
What are their names?
Chandra Smith is my one aunt, and Cheryl Marlin is my favorite aunt.
All right, how long have they resided in this area, in the Central Florida area?
Yeah, as long as I've been alive, so they're most of their lives.
Your Honor, that's all the testimony. I just had some brief comments regarding the affidavit in support of the arrest warrant, Your Honor.
Let me ask, does the state have any questions?
No, Your Honor.
Thank you. Go ahead, Counselor.
Your Honor, very briefly, this is a search warrant case of 1806 Deanna Drive in Apopka, Florida, which occurred on May 7th, 2021. As stated within the affidavit, there was no one present at the residence on that day. Jason Richardson was not present at the residence on the day of that search warrant. In fact, according to the affidavit in support of the arrest warrant, Mr. Richardson does not own that residence. It's owned by someone by the name of Kevin Revere, last name R-E-V-I-E-R. There's no evidence to support any suggestion that Mr. Richardson had any possessory interest in that residence on Deanna Drive on May 1st of this year, or that he was exercising any dominion and control over any area of that residence on that date. This is not an actual possession case, so the contraband seized from the residence on that day that's listed within the affidavit, it's not actual possession. We would ask that the court consider a bond reduction under these circumstances, and we're asking that if the court would consider a bond in the amount of 20 grand, but that is the defense request, Your Honor.
Total for all the counts?
Yes, Your Honor.
All right, and I pulled up the affidavit again. hold on, I need to review something because I understand what you're saying, but it confuses me because that's not what I recall reading. I see on May 1st, 2021, at approximately 12:30 a.m., Orange County Sheriff's Office was called to 1806 Deanna Drive in reference to a petty theft. The individual who called identified himself as Jason Richardson. When they arrived, Jason Richardson answered the door. But you're saying on a different date is when the search warrant was executed?
That's correct, Your Honor. According to the the affidavit in support of the arrest warrant, it was May 7th.
Oh, I
that
see,
the
on May
residence
7th.
was searched. It's the defense position that Mr. Richardson was not residing at that residence on May 7th and had no possessory interest in that residence on May 7th. And clearly, as stated within the affidavit, the house is owned by this Kevin Revere. Mr. Richardson's name does not appear on any lease and certainly does not appear on any deed or any mortgage.
What says the state?
Your Honor, I'm re-reviewing the affidavit, and I believe I saw somewhere where they recovered the drugs. There was also mailed to Mr. Richardson. And in addition, on May 1st, when the police were called regarding a petty theft, he said he lived there with his wife, which is only 6 days prior, Your Honor.
I see that as well. It says that in the bedroom, they located 158 grams of methamphetamine, 9 mason jars filled with approximately 117 grams of cannabis, a knife with the name J. Rich sketched on it, pawn shop receipt with Jason Richardson's name on it, various pieces of mail belonging to Jason Richardson, photographs of Jason Richardson, one of which includes him and his mother, the vehicle title belonging to Jason Richardson.
Your Honor, if I may interject, just very
Yes, please.
briefly, it will be the defense's position, let's say if this case were to proceed to trial, that Mr. Richardson had left that residence and no longer lived there as of 2 days after that May 1st contact with law enforcement. So again, it's the defense's position that he was not residing at that residence on the date of the search warrant, which is May 7th, and that he may have had some belongings there, but certainly that does not establish. That's, maybe circumstantial, but a very, not the strongest circumstantial case as far as arguing possession.
All right, what's the state's response to the defense request for bond?
Your Honor, I believe the $100,000 is according to the bond schedule, and I've not heard anything other than the defendant has ties to the community, which I don't believe is relevant to the bond schedule. I would leave it as is, Your Honor.
Your Honor, if I may, by my count, the traffickings, it's $100K each, so that's 200. If you add the 3 felonies at $5,000, I believe it's a total of 215 as of right now.
It is.
Yes.
All right. Here's what I'm going to do. I will reduce the bond. I'll make count 1, the bond is $50,000. Count 2, it's $20,000. Count 3, $1,000. No. Counts 3, 4, and 5, I'll treat as subsidiaries, so they'll be $150,000. You're not allowed to possess a weapon of any kind, firearm, or ammunition. Do you understand?
Yes, ma'am.
You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers or any witness in this case. Do you understand?
Yes, ma'am.
I'm going to order that you're only allowed to return to this residence one time with law enforcement to gather your belongings, but after that, you can't be in this residence. You understand?
No problem. Yes, ma'am.
All right. Good luck, sir. Thank you, Counselor.
Your Honor, nothing further. Thank you very much.
Have a nice weekend. Sir, please tell me your name. You're here in 21 MM 4565, charged with trespass on property after warning.
Yes, ma'am.
There is probable cause here. Does the state have an offer?
It's an adjudication of guilt, credit time served, and no return to 5265 South John Young Parkway.
Is he interested in that?
Yes, Your Honor, I did have a chance to speak with Mr. Ellis about the state's offer as well as the repercussions of entering a plea of no contest today with any citizenship probationary issues as well as the rights to be waived on the plea form, and he understood what we talked about, and he still wishes to enter a plea today.
Please raise your right hand, sir.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, you heard what the attorney just said. Is that what you wish to do here today?
Yes, ma'am.
I'm not appointing him to represent you, but as a friend of the court, he did talk to you about the rights you're giving up. Do you have any questions for me about those rights?
No, ma'am.
You understand if you're not a U.S. citizen, you can be deported?
Yes, ma'am.
All right, at this time, how do you wish to plead to the charge of trespass on property after warning?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, order that you're not allowed to return to that shopping plaza. You can't go back there, you understand, sir?
Ma'am.
I have to order that you pay court costs. I'll reduce those to a lien.
Wait, thank you.
Good luck, sir. You have 30 days to appeal in writing.
Yes, one.
Is what?
1 day.
Oh, 1 day. I'll give him credit for that. Please tell me your name.
Christopher Goodnight.
21 CF 7814. You're here charged with battery by strangulation and domestic violence battery. I'm going to appoint an attorney to represent you. There's probable cause in this case. Does the state object to pretrial release?
No, Your Honor.
At this time, I'm going to place you on pretrial release with special conditions. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You can't possess or consume alcoholic beverages, and you'll be subject to random alcohol screens. I'll order you must maintain a separate residence, and I'll allow one-time return with law enforcement to gather your belongings. Good luck, sir.
Yes, ma'am.
Please tell me your name.
Tuneli Perez.
21 CF 7815. You're here charged with battery, domestic violence, and tampering with a witness to hinder communication to law enforcement. There is probable cause. I'll appoint an attorney to represent you. At this time, I'm going to place you on pretrial release with special conditions. You can't have any contact with the victim. Do you understand what that means?
Yes.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow one-time return with law enforcement to gather your belongings.
Just a quick moment, Your Honor, just to ask a quick question. Thank you, Your Honor.
All right, good luck. Sir, please tell me your name.
Jamal
What's your last name?
Rumfield.
21 4568. You're here charged with battery, domestic violence. There is probable cause in this case. I'll appoint an attorney to represent you. Could he qualify for mental health pretrial release?
You can have the screen, Your Honor.
That doesn't sound promising.
Your Honor, I would set a monetary bond and a no contact order would be sufficient, I believe.
I will. I was just trying to see if we could get some help, but.
I appreciate that, Your Honor.
Sir, your bond is $500. You can't have any contact with the victim. Do you understand what no contact means? Did you say yes?
Yes.
All right, you can't possess a weapon, firearm, or ammunition. Do you understand?
All right.
And were you living together?
Yeah. Yes, Judge.
All right, you can't live with him now.
All right.
So I'm going to order separate residence, allow one-time return with law enforcement to gather belongings, but you two can't live in the same house, okay?
All right.
And Counselor, can you make a note in your file about this case, because I'm looking at the history?
Yes,
All
I
right.
will, Your Honor.
Good luck, sir.
Neves Rodriguez is medical.
21 MM 4566, it's also domestic battery. I'm going to appoint the Public Defender's Office.
Oh, we'll waive the appearance, Your Honor, I'm sorry.
It's okay, I assumed that you would, because otherwise he sits at no bond. Or she sits at no bond, I'm sorry. There is bond, it'll be $500. No victim contact, no weapons, firearms, or ammunition, maintain separate residence, one returned with law enforcement. Please tell me your name.
Paul Katik.
Twenty-one CT 607, you're here charged with driving under the influence. There is probable cause. I'll appoint the Public Defender's Office to represent you. I'm going to place you on pretrial release and also require that you post a monetary bond of $500. With special conditions, you're not allowed to have, you can't possess or consume any alcohol, and you'll be subject to random alcohol screens. Do you understand? You can't drive without a valid Florida driver's license, and you can't possess or consume any controlled substance. You'll also be subject to random drug screens. Good luck, sir. Twenty-one CF 7807, I'll appoint the Public Defender's Office.
We'll waive the appearance, Your Honor. Did you also have any concerns while reading this affidavit, Your Honor?
Wait, what?
Did you have any concerns reading this affidavit as well, Your Honor? As far as mental health?
You mean mental health issues? Possibly.
I'm going to make a note to our office as well. But I would just have to set a monetary bond.
I will. It'll be $5,000 on count one, and I'm going to reduce count two to $150. Not return, no victim or witness contact, no weapons, firearms, or ammunition. Please tell me your name.
Esteban de Jesus Duran.
21 MM 4562. You're here charged with 3 counts of providing false identification to law enforcement officers. I'm going to appoint the Public Defender's Office to represent you. There is probable cause. Your bond is $500 on count one, $100 each on counts 2 and 3. Additionally, a warrant was issued for your arrest in 19 CF 3561 for violating your community control by changing your residence without first procuring the consent of your probation officer, by failing to report to the community control officer as directed, and by failing to remain confined to your approved residence as directed. There's no bond authorized on that. I'll appoint an attorney to represent you in that as well. In 19 CF 3561, you're also here charged with violating your probation. There's no bond on that charge, and I'll appoint an attorney to represent you in that one as well. Good luck. Please tell me your name.
David Emilio Santana.
19 CF 12163. A warrant was issued for your arrest for violating your probation by testing positive for cocaine and failing to undergo a drug and alcohol evaluation as directed. There's no bond authorized on this warrant. I'll appoint an attorney to represent you. Good luck.